Here are some of the biggest mistakes that I see as an estate planning and an estate administration attorney. Hi everybody, I'm attorney Michelle Conti of Conti Law, and I wanted to go through a couple of the things that I see that are big no-nos. Number one is do not write on an existing will or trust instrument. Even if you want to make changes, I have people all the time who will bring in copies of their original documentation and have a whole bunch of stuff crossed out. They'll initial and date it. Let me tell you, that will force us to go immediately to court upon your death because the judge wants to make sure that that's a valid correction. And oftentimes that will get thrown out. So don't write on the original documentation. Let's just do a basic update, amendment, codicil to the document you already have. Also, don't store your estate planning documents in a safe deposit box. Number one, if you need those when that bank is closed after hours on the weekend, you don't have access to it. But more importantly, when you die, an inventory of that safe deposit box has to be done. And we can't get the inventory without the original will. And if we don't have the will because it's in the safe deposit box, we do have to petition the court and get the court's permission to enter the safe deposit box. Never name a minor child as a beneficiary on any account, whether it's retirement account, life insurance, because in Pennsylvania, if a minor child is appointed as a beneficiary and they haven't turned 18 yet, then we have to go to court and we'll have to have a limited guardian appointed on behalf of that minor child. And typically that limited guardian will be the attorney of record until they turn 18. Also, do you want your children to inherit outright at the age of 18? Most of my clients do not, and they want those funds secured until a later date so that the child doesn't have a blank checkbook to do what they want with those funds. Also, don't name multiple executors or multiple trustees. I have people who do want to do this to make everything transparent and fair, but keep in mind that if you have multiple people acting on your behalf, they have to be together. So if they don't live close by, if they don't live in state, this may cause problems. I always tell my clients, don't ever add a child to your deed. There's various reasons, but if that child gets into creditor difficulties, bankruptcies, divorce, then your asset might be up for grabs for that child's settlement. But additionally, when that house is sold, there'll be capital gains tax to that child. Instead, we can either create a power of attorney authorizing them to manage your real estate or even your bank accounts during your lifetime. And then when you pass away, the executor or trustee of the trust can manage those assets. Also, if your child is unable to manage affairs or is too young or is going through some stuff, maybe we're not going to name them as a direct beneficiary, but rather name a remainder trust, or if you have a revocable living trust already, we'll name the trust as the beneficiary so that the funds will go to them. It'll be for their benefit, but it won't go to them outright upon your passing. Stay tuned for more tips.